not just for organizing the conference itself, but especially for the opportunity that this sort of Jubilee conference provides to stop and think beyond the boundaries of any given present research or the specific answer that might be proposed. That is precisely what I shall endeavor to do here. I'm not presenting existing research, but rather a suggestion for an intellectual project in the particular junction at which we stand, for a new direction of study which may be meaningful for both general and Jewish law. Talking about systems, I will be very general, and I will use the forbidden phrase, Jewish law says. The legal system in Israel, but not only in Israel, is coping with a phenomenon that, although not new, has taken on dimensions that must be addressed by the research community. The phenomenon of the vanishing trial. The legal system with which we were familiar, in which judges adjudicate based upon law, and the question of whether they should stray from those laws or reinterpret them, is steadily disappearing. Conflict resolution movements, along with therapeutic jurisprudence and multicultural perspectives on law which actively object the advancement of a single unified legal narrative, only add to the impossible load placed on the judges' shoulders and the public's dissatisfaction with the long, exhausting legal processes that leave the site injured and angry for years. All of this influences and reflects one simple phenomenon. Courts no longer do law. Without distinguishing between different courts and types of cases, the raw numbers are astonishing. Some say 88% of the cases, some 90%, and in the United States there are those who say that more than 98% of cases do not conclude with a classic legal decision by the judge. Various types of alternative procedures take the place of traditional court decisions, leading to decisions that cannot appealed or are not subject to judicial review, do not continue the production of a new law, and whose relation to positive law must yet be defined and researched. The age of the vanishing trial challenges the entire world of law as we have known it, and raises a plethora of questions. How will such system function over time? Will it have any legal guidelines in the event that it ceases to produce its own legal precedents? What sort of relationships will be built between the academy that researches law and the legal system that does not perform law? What type of lawyers will such a system require, and what training will suffice for its judges? Will traffic officers enforce laws, and if so, which? And which legal fields will remain beyond the scope of compromise and mediation and will not vanish? The legal world is searching for answers. Both historical and halakhic materials reveal that courts of Jewish law frequently preferred settlement over pure legal solutions. This was perhaps the result of an active preference of the compromise based on the aspiration of a law of peace and involving, in some sources, therapeutic jurisprudence. Alternatively, the preference may have come from lack of other options or from concern from negative effects that may arise from adjudicating based on Torah law in a culture of dispute and multiple voices. It can also come from external pressures stemming from the courts standing as a not always legitimate alternative to the sovereign legal system and lack of authority. Such a system, which forgoes stability and certainty for the sake of other values, places the judge and his action not the law, in the center, challenges the world of research from several directions. Many talented researchers who dealt with the concept of compromise in Jewish law have attempted to define its multi-faceted character. The world of Jewish law is searching for answers too. This is the point at which I suggest collaborative thinking. With a history of hundreds of years of communal legal system based on alternative procedures, the study of Jewish law can provide an answer not only for itself. I do not mean to suggest conducting comparative law research. I suggest developing jurisprudential insights regarding judicial conflict resolution, which may lead general research to renewed thinking about legal system, its relation with the law and its development, and its relation with legal research generally, and the training of lawyers and judges particularly. Jewish law's extensive dealing with the field of settlement, which may have been considered as an obstacle in the age of dogmatic, formalistic trial and research, is revealing itself in the 21st century as an advantage. Jewish law may also stand benefit when it comes to a deeper understanding of the many alternative decision-making processes in the world of Jewish law. Modern discussions which exact and elaborate such proceedings may provide tools and names to recategorize disputed Talmudic topics. In what follows, I will attempt to exemplify the structure of the process from both directions. I will begin with the potential gains for Jewish law, or in praise of conceptualization. Before the advent of the ADR, Alternative Dispute Resolution movement, and similar movements, the meaning of settlement in Western law was very narrow. Jewish law researchers who attempted to introduce halachic sources with said narrow meaning read the various sources through its lenses, mainly producing conceptual and philological works on terms such as bitzua and pshara. The expansion of the world of alternative proceedings in the ADR era has clarified that there is no need to arrive to one singular interpretation. It has sharpened and enriched the discourse and our different possible readings, all with proper caution against anachronism, of course. If we identify the judicial process as proceedings in which at least one of the sides is present against his will, in which the adjudicators are not assigned based on the litigants' wishes, and in which the results are dictated by law, or at least by the judge's own understanding of the proper application of the law, then alternative proceedings may diverge to some degree from any one or more of these characteristics. The process itself may be different, the litigant's degree of agreement with the steps taken during the proceedings may be different, as well may be the result. In law-based arbitration, the sides agree to the adjudicator's identity, but the results are similar to those of standard judicial proceedings. This is how Bar suggests to understanding Talmudic compromise. A decision by a judge which diverged from the result that award 100% of what one of the sides deserved by law is generally referred as compromise. Chaim Shapira is of the opinion that this is the meaning of bitzua, and that is how Itai Lichis proposes understanding Talmudic pshara. For the sake of accuracy, I will refer to this as forced compromise, since the results after the judicial decision are mandatory. Today, proceedings which combine agreement both to the identity of the adjudicator and to the result, results, which may not be based on law, are generally referred to as arbitration, a compound which became a reality of life for Jewish law due to both external and internal circumstances, as I mentioned before. Itai Lifshitz adds that the Rishonim understood the difference to lie in the process as well as the result. The judge does not give a decision of compromise, but functions as an intermediary and offers a sort of mediation process. Another option is removing the litigants from the court and encouraging them to come to an agreement without an intermediary. Tz'u u'vitzu. As Gulick suggested, bitzua, outside, pshara, inside. And in modern terms, a settlement agreement which receives the approval of the court. An analysis shows that there is also a place for Howard Zer's restorative justice and conferencing in the sources, if we agree to include non-exclusively civil cases in the discussion. As Maimonides concludes in the Hilchot Tshuva 2.8, the proper ending of a conflict is in pleasing and appeasing the injured party, and depends on the ability of the injured party to be appeased and truly forgive the injurer as well. So, 5 central concepts, 6 if we include criminal proceedings, play a role in this temporary analysis of Jewish law sources: arbitration, law-based arbitration, settlement agreement, and forced compromise, and mediation and restorative justice. Exacting work based on these concepts, even though some of them don't appear in the halachic sages' vocabulary, of course, may well enrich halachic rhetoric and aid it reaching precision. I suggest, for example, that greater space be given to rereading sources and speaking about mediation and intermediary. There are sources that explicitly emphasize elements from the field of mediation, such as leading the sides to neutralize hostile feelings, aiding them in parting as friends, the work of Aharon in approaching each side separately in order to soften his anger, solutions of enlarging the cake, such as the story of the king of Katya. Moreover, there is a series of Talmudic sources which are interpreted as forced compromise, though they can equally be interpreted as mediation, or sources that raise interpretive uncertainty in which mediation appears to be the optimal interpretation. Rabbi Eliezer ben Rabbi Yossi Adeli, emphatic objection to bitzua, as recorded in Tosefta Sanhedrin, is commonly attributed to an adjudicator forcing compromise rather than mediation. Rabbi Eliezer's language, asur livtzua, does not indicate an interpretation, or one interpretation or another. Yet one of the claims for understanding the source as forced compromise is by elimination. The performance of Rabbi Eliezer speaks of cannot be interpreted as mediation that is meant to lead to a mutually agreed upon result, since that is not considered as an act which could inspire such anger in Rabbi Eliezer. Well, it can inspire. It should be noted here that the world of legal dispute over ADR of the last quarter of the 20th century shows just how greatly the possibility of mediation is seen as a threat by the people of the law. Owen Fis, in his article Against Settlement, represents and clarifies this in a series of weighty claims, which I will refer later. There are more examples of uncertain sources, which are commonly interpreted otherwise, and for which I believe mediation is the best suited interpretation. In early Midrash from Sifrei Bamidbar, chapter A, Numbers 95, in which Moses liaises between the Israelites and God during the story of the people's desire for meat. The people say mockingly, this is a compromise. They believe Moses to be a simple mediator who does not have the power to grant our wish. The story in Vaikra Rabbah 6:5 is similar. And I quote, "We heard his voice from the fire." Rabbi Jonathan stated, they made a compromise, compromising, that he does not deny them and they do not deny him. It is suggested that this be interpreted as settlement agreement or division and allotment. It seems correct to me that the agreement which described in the beginning of the reception of the 10 Commandments emphasizes, of all things, Moses' mediation in telling the people the rest of the 8 Commandments as demanded by the people after they heard God's voice from the fire. In the continuation of that same Midrash, when discussing the Israelites' punishment for their sins, the verse from Eicha, Lamentation 2:17, he carried out his word, is interpreted as compromise of a settler. In the very difficult context of this verse of Lamentation, in which it is written, he destroyed and had no compassion, haras velo chamal, it is not easy to claim that this is a case of a compromised punishment. It seems to me that the emphasis is on the punishment via the enemy, the oppressor, who are mentioned in the verse and in the Midrash, meaning punishment through a mediator. I will conclude the first section with a few words on the Rashbam's commentary on the Gemara quandary over whether it is better to adjudicators allot 100% of the contested money to a person he believes more likely to be its owner, in a non-clear-cut situation like Shuda de Daine, or if it is preferable to divide the money between the litigants in a manner of identical to classic forced compromises, which allot 50% to each side. Rashbam, attracted by Babatra 35a, and I quote, Shuda de Daine, to the one towards whom the adjudicator's heart are inclined to think that the overloved end was close to, and certainly decided to bestow his wealth upon. To him, they grant the land. But when they divide, one side certainly takes a half that is not his, that is not rightfully his. Rashbam proposes a fascinating discussion. On the one hand, if the adjudicator decides based on Shuda de Daine and awards the estate to one of the two beneficiaries, judging by the results, one side has 100% and the other has none. But judging by the truth of the matter, there is 50% chance he's right. There is no doubt that this is meant to award the property to only one beneficiary, such that there is 50% chance that the adjudicator acted according to the deceased's will. On the other hand, if the adjudicator rules for a settlement and divides the money between the two litigants, it is well that that will result in each side receiving 50%. But judging by the truth of the matter, that is 100% mistaken. The deceased certainly did not mean to divide his estate in half. This analysis is a seemingly strong argument against the alternative proceedings, yet this is precisely the place in which exactitude can be achieved by modern proceedings. The case in Bhavabhata assumes one story with one truth. It is possible that when it is clear that more than one story is involved, and that the picture is complex, and there is a multiplicity of voices, that we will prefer to forgo the adjudicator's discretion in granting 100% to one side, and turn to processes whose proceedings involve a multiplicity of voices and in agreement. And now to the second section, Jewish law's possible contribution to the uncertainties surrounding the vanishing trial phenomenon. As I said at the outset, alternative proceedings have become a fact on the ground over the last several years. They are a fact that raised and still raises much criticism. Were Jewish law to be volunteered as the Western law's guinea pig, in hindsight, its hundreds of years of experience might lead to join the critics, but it might also offer its own ways of coping with some of the reservation over the legal system that does not go to trial. I will focus here on three of the criticisms, following the writings of Michal Alberstein. I will use arguments from the sphere of law and rights, law and society, and law and political thinking. Law and rights. The central claim here is that a legal system which does not go to trial does not, in practice, produce law. Judicial proceedings, according to Owen Fiss, and in his article Against Settlement, have an essential role in creating, establishing, and implementing rights. They are a tool for social change, for clarifying public values, and defining them. Assuming the Anglo-American system, which is built on precedent, when there are no precedents, there is no law. Moreover, the plethora of negotiation arrangements will erase years of achievement that lead to the production of current norms. The claim is that the ADR movement goes against the court's development and turns back the wheel. An alternative arrangement which leaves the disputed topic to power-based negotiation and risk, injuring the weak, missing the public element that exists in court proceedings, and relegates public rhetoric to discussions among neighbors. Law-based judgments deter inappropriate behavior, establish proper behavior, adjudicate based on facts, and dictate public narrative. They lend legitimacy to the use of force and lower negative externalities. How can we deal with such arguments? Well, we could admit that yes, the legal system loses all these things, but prefers to gain discourse, non-antagonistic dialogue, a law of peace. Those are no less important public values. Most people who deal with Jewish law seem to view the halachic world explicit preference for settlement in this light. I, however, believe that two more complex answers are hiding between the lines. The first answer, Frank Sander, the father of the modern mediation, already suggested that not all cases go to mediation. An organized check must be done to determine which topics require creation of a new public narrative, which topics are at elevated risk that going to negotiation will turn into blackmail, and those should not always go to trial. Trial has advantages in certain cases, and alternative solutions have in the others. In studying Jewish law, I would like to suggest also a third parameter. There are cases which should not go to negotiation because the law-based result for them is so obvious that there is a greater chance that negotiation injure a right that should be protected by the court. In analysis of a series of halachic sources that restrict settlement to cases in which the adjudicator does not immediately know where the case will lead, may contribute to these parameters' accuracy. Jewish law experience also indicates that sides to the conflict may be allowed to choose whether to go to trial or attempt a settlement. Various interests will influence the side's choices, and there will be ultimately be cases that go one way and cases that go to another, but most crucially, the sides will have greater autonomy. The second, perhaps more important answer with regards to the Jewish law's contribution to discourse is that these values can be obtained in a legal system that lives most of its life in a sphere of compromise. First, of course, Jewish law applies its own system of execution on alternative judgments. The boycott that the community imposed on those who did not pay their debts did not depend on whether the debt was reduced in half by a settlement. The institution, not the content of the given case, grants legitimacy. More importantly, however, the history of Jewish law offers other ways of maintaining public discussion of values and the development of law. The study in the Beit Midrash, the interpretive discourse, the attempts to create various codices, the extensive responsa literature, all coexisted alongside a system that did not always wait for the answers of the respondents and apparently preferred settlements. There is no reason to assume that the court is the only place in which to hold the legal discourse. Note, the existence of the court itself is absolutely necessary. The crisis in the development of discourse in Jewish law following the emancipation and the reduction of queries addressed to the Jewish Beit Din may attest to this. So the general system can learn from the Jewish law and adapt similar practices to study and to teach law and its logic to the public, to continue to strengthen creativity and critical thinking in law faculties, and to come with new options for cross-border consultation between academia and judicial system. Law and Society. Mark Gallanter represented the School of Law and Society, has a number of claims regarding the ADR movement. His positive claim is that a law-based system, especially the returning player who knows how to play the game, has an advantage. It is best for the one-time player to be represented by a lawyer who can function for him as a returning player. Alternative proceedings are, in a sense, more suited to one-time players. It is true that Jewish law can contribute from its experience as a basically lawyers-free system meant for one-time player and whose legal presumptions, chazakot, are not suited for returning players. The School of Law and Society criticized the ADR movement as sounding a superfluous cry because of the load of the courts is not so heavy. Gallanter believed that it is a sort of urban legend and that the public wished to claim that the court system would not last for ideological reasons. It will be interesting to follow the history of the Jewish judicial system, which declared that it would no longer adjudicate criminal law because there are too many murderers and not all could be tried. The Talmudic system defined the entire area of knasot, fines, as a subject to alternative proceedings, but in practice continued to try common monetary cases. Checking this story may be a fascinating exercise. Galanter describes a naming, blaming, claiming process in which the injured learn to call the injury by its name and define it as a legal right, then can blame the injurer, and then can sue. He believes that this description indicates that many cases have still remained outside of the system, and the number of the legal cases will grow in tandem with the society's growing awareness of rights. Law is the result of a social construct. It may be interesting to check as a suggestion for discourse and research if in Jewish law's many years of ADR experience, the processes were ever halted before the stage of claiming. I propose two directions for examination. First, a society that knows law is more capable in defining the rights of the injured, yet perhaps such knowledge would produce fewer injuries. This is to say that the potential injurer's knowledge of the law may serve to deter him. Learning and knowing the law places clear boundaries between what is and is not permissible, and they may at least aid the good children who do not wish to break the law.
Hila?
A second direction would be to examine if the exact definition of sanctions and formalistic legislation would prevent unnecessary proceedings. Midot v'shiurim. This is another historical step, the Jewish law system in preferring confessing and loans, הודאות והלוואות, over cases that required assessment. This would, of course, require clear laws, and that, in that sense, more thought must be put into formal laws, with clear measures, as Jewish law prefers. When transferring to a system that does not adjudicate based on law, the law must be so clear to be able to direct behavior beyond the walls of the courts. Extensive legislation of amorphous concepts as the reasonable person is suited for courts and encourage legal procedure.
יש עוד דקה. 1 minute, please.
Well, I'll skip the last criticism. And some with this. I just sought to raise the institutional discussion with which the Israeli legal system, as well as legal systems in the world over, are so caught up with. Where is the legal system in the world of vanishing trial heading? I propose that energy be invested in this intellectual project, and my belief is that sober, conceptual discourse, without claims regarding guaranteed influences or anachronism, can healthily challenge both systems.